Hello, I'm Natalia Angelini.
And I'm Domratchev.
And welcome to Helen Estates. You're listening and watching episode number 561. Today we're going to be talking about a recent decision that we found to be of interest. It's in the matter of the estate of Andrew Hrabovsky, if I'm pronouncing that correctly. And it really deals with the question of will challenges and the issue of the applicable limitation period. And it also touches on, of course, the issues of capacity and undue influence. And we will briefly address those, but more so focus on the limitation period question, since that was one of the primary issues. And maybe we'll just start with some of the facts.
Yeah, so this was an application that was brought by Gail Shannon against her brother and her uncle, who were the estate trustee of the deceased Andrew Hrabovsky. She challenged the 2007 will that was executed by the deceased on the basis of lack of capacity and undue influence. Of interest is the fact that the testator died on November 15th, 2014, but she didn't actually issue the application until December of 2016,
Right.
which would be
A little over
2 years.
over 2 years.
Yeah.
And the testator had done 3 wills in total, right?
2 wills.
Right.
The previous 2 wills treated Gail and her brother fairly equally, and then the last will has essentially left the residue to Gail's brother Glenn.
Right.
And interestingly enough, if you were to predecease the testator, it would go to his children. So Gail's children were also
Right.
cut out of the will.
So it was markedly different from the first 2, which had many more, several more similarities. And interestingly, after the 2007 will was done, apparently the testator went to Gail, said, I don't know what I just signed, and, I'd like to go to another lawyer to have a consult. So she took him to a lawyer. He met that lawyer in private with the intention of doing a new will, and the lawyer declined to proceed with the retainer because there were some concerns about capacity, and the lawyer also had some concerns about undue influence, as the testator was accompanied to the lawyer's office by his daughter, although the meeting was held in private. And although this wasn't addressed in the decision, it did sort of ring a bell for me because, if you sort of follow this forward, you could have a scenario where that lawyer is getting sued for having failed to draft a will where there wasn't necessarily certainty as to a lack of capacity, but just a concern. And we do know the law is that, in that scenario, if you've got a client who you may have some concerns about capacity, but you're not sure, and maybe it's an urgent situation where a will would need to be done, we are to err on the side of caution of doing the will and just meticulously documenting that whole process.
Especially in light of the fact that the testator in this case had lost capacity shortly thereafter. It was clear he could not execute a new will.
And even though he died several years later, so that process just, fell by the wayside, and then no new will was ever done. So moving on to this then, carrying forward, he passes away, the will challenge is brought, and, there's several issues before the court, one of which is the propounder is asserting, well, hey, you've passed the 2-year deadline, so you're statute barred for bringing your challenge. And the objector's argument was accepted by the court, and the argument in essence was, well, I didn't receive notice. I didn't receive the will until about, I think, a month or 2 later, or post-death.
Yeah, it was a few months later, so she didn't find out until January 2015.
Right. So the 2 years should really run from that point on. And I did commence my claim within that 2-year time frame. And this argument was accepted by the court. And in doing so, it was Justice Wilton Siegel who heard this matter. And it's actually not clear to me. I think it may have been an application hearing, like heard without oral testimony. But he did look at some of the applicable case law, and was very clear in discussing the libel case, which is the 2014 case of the Honorable Justice Greer, wherein she had held that a will challenge application was statute barred. It was similarly, more than 2 years post-death, but the difference was
it was 2 years after she discovered. So
the circumstances, I think, were such that the rule of discoverability, didn't save the objector.
Right.
Whereas, and some practitioners, I think, after the Greer decision, may have been treating it as though there's a fixed 2-year limitation period post-death. And to err on the side of caution, that's not a bad way to be advising your clients, right? We don't know. It may be a hard 2 years post-death. But Wilton Siegel looks at that and says, well, no, it's not a hard deadline. It's the discoverability principle still applies, and Justice Greer actually applied that in coming to her decision.
Yeah. In that particular case, then you have to rely on the evidentiary record to show that you were not aware of there being a will or the circumstances of the will, because I would imagine that even if you were aware that a will potentially existed, that could be used against you to say that the limitation period was still running from that point on. So it's not necessarily that you get a copy of the will. I think
right.
It's when you are aware that there may be a will out there.
Right, and I mean there's some gray there, right? How is the court going to interpret what amounts to having the sufficient facts or the sufficient information in place for the limitation period to kick in. And in this, so in looking at the Limitations Act, right, we're looking at sections 4 and 5.
Yep.
If I'm right. And so right, so Justice Wilton Siegel was looking at section 5, which creates a presumption that an applicant has knowledge of the contents of a will on such a date.
Yeah.
But in this case, that presumption was rebutted.
Yeah.
So, and His Honor also looked at the Bertsu and Macron decision, and where I think it was a similar analysis where the judge did expressly apply the discoverability principle. So I guess our takeaway is the discoverability principle was not done away with from the libel case. It is very much something that a court can consider.
Yeah.
And should consider when looking at the question of a limitation period.
Yeah.
How about we touch on the question of capacity briefly, maybe?
Yeah, I think we've covered the issue of the limitation period. It was also interesting how His Honor discussed the question of capacity here and how he sort of used the evidence of each side to make a determination of, in this case, that the testator did not have the capacity to execute this will.
Right, and each side had medical professionals that they were relying upon, and His Honor preferred the medical professional relied upon by the objector. And that professional did seem to have more interaction with the testator at the relevant time, right?
It seems like he made a diagnosis. In fact, I think His Honor in the decision noted that the expert whose evidence was used by the respondents did not really make a diagnosis so much as the objector's expert did. And also another thing that he noted is that the objector's expert provided affidavit evidence and was cross-examined, whereas the expert on the other side was not.
Right, and I guess that brings us back to, having the evidence tested and that carrying more weight, or having the better likelihood of carrying more weight when the matter's heard in court. And what was really interesting to me when we looked at the question of capacity was really the time-specific nature of it, because this testator sort of was doing fine and then wasn't doing well and then was improving. And the objector's argument was, well, yeah, he had good days and bad days, and I say he did this will on a bad day. And when the court looked at all of the other circumstances, the relationship, that nothing changed in terms of their relationship between the penultimate will and the last will. Yeah. And looking at the medical evidence around the time of this last will, which was leaning towards he was not doing well, because he did have multiple strokes throughout his life. So really looking at the when things were happening, and then coming to that conclusion as a result of that. So, and it really is such a it's not an easy thing to sort of pinpoint, right, when we're looking retrospectively. So I felt like the court did a thoughtful analysis on that issue.
I also find it interesting that the applicant, the objector in this case, did agree that he had some good days and some bad days. So she didn't go for he was incapable conclusion,
Right.
but rather she conceded that he had good days and bad days, and in a way that sort of limits your argument a little bit. So I think maybe that also helped in the ultimate decision in her favor.
And in contrast, the propounders were saying, well, no, he was perfectly fine until 2012. Or I'm exaggerating, but
I think it was. I think they're saying that he was pretty much okay.
Right. The tenor of the argument was he was fine until 2012, and by the medical evidence of both sides, that was clearly not.
Yeah.
That was not consistent. Yeah. So I think that may have hurt them a little bit, and so. So collectively, I guess the judge, considering everything, found the objector's evidence more reliable. And on the question of undue influence, I think we could sort of just briefly state that he did not find that that argument could be successfully made. So the will was set aside purely on the basis of lack of capacity.
That's correct.
So unless you have any other thoughts to add, Kira, I think that brings our podcast to a close.
That's right.
So until next time, we want to thank you for listening and for watching. I'm Natalia Angelini.
And I'm Kira Domratchev.
Should you have any questions, please email us at webmaster@hollandhall.com or leave a comment on our blog.